Welcome to Scars of the Past Ministry. I am your host, Patty Adams, DTM and MSP. Scars of the Past is a nonprofit ministry that supports and assists victims of sexual violence. We do this through a holistic approach that allows the victim to become victorious through building faith, trust, resilience, and character. By doing this, the victims will be able to approach life with hope and be productive in their society. We are very passionate about educating our community on ways to stay safe and guarding themselves from the enemy. Our motto is "We stand against violence, we stand for freedom." Our desire is no victim will live with lifelong scars, but instead will be able to walk in the destiny that God has chosen for each of them. Our previous podcasts have been a message on parents teaching their children about appropriate and inappropriate touch, how to write a victim's impact statement, and learning about the statute of limitations. Today, we will take you inside the courtroom to prepare you for a court hearing and familiarize you with the court system. RAIN, which stands for Rape, Assault, Incest National Network, has a great deal of articles on this topic. Please check out their website at www.rain.org. All of the information given today is a direct quote from RAIN's website and J.S. Berry Law website, with the exception of the last few paragraphs, which is my personal testimony when dealing with the courts. Let's begin. Know your rights. The rights to apply for crimes victims' compensation. The right to attend criminal justice proceeding. The right to certain protections from intimidation and harassment throughout the trial. The right to be heard and participate in criminal justice proceeding. Be sure you find someone to support you. It can be a relative, a friend, or even your pastor. Who will you be talking to? Defense attorney? This lawyer represents the alleged perpetrator. It can feel like this person is against you at times, but it's important to remember they are simply performing their job. If you can, try not to take their words or tone personally. They will ask you questions during the part of the trial known as cross-examination, which occurs after the direct examination. Prosecuting attorney. This lawyer represents the state in the case against the alleged perpetrator, also referred to as the defendant. They are also responsible for arguing why the court should convict the defendant. While the prosecutor is often on your side, it's important to remember that they are not your lawyer. Prosecutors have a duty to the general public, the state, and the laws that the perpetrator violated, not necessarily to your personal interests. The prosecutor will ask you questions during the portion of the trial known as direct examination. More than likely, the prosecuting attorney will review the questions they plan to ask you in advance and help you prepare. Your role as a witness. Your role during the proceeding is to answer the lawyer's question and any questions the judge might ask. This can feel very intimidating at times. Often, survivors are also provided an opportunity to submit a victim's impact statement, and we spoke about that in an earlier podcast. But to learn more information about victims' impact statement, you can go to National Center for Victims of Crime. I also spoke to you in an earlier podcast about the difference in a civil case and a criminal case. So, a civil sexual assault case is handled by the accuser, usually as represented by their attorney. And this person has the right to decide the direction of the case, including evidence presented and damages asked for. In a civil case involving sexual assault, instead of suing for sexual assault, the accuser sues formally for charges such as assault, battery, intentional infliction of emotional distress, or false imprisonment. If a civil sexual assault trial results in confirmation of liability of the accused, he or she may have to pay the accuser and/or their family damages, including legal fees, compensation for medical expenses, psychological damage, damage to relationship, lost wages, and so on. A sexual assault defendant can be tried in civil court by an accuser even if a criminal court declared the defendant innocent of a crime, and an accused person can be charged criminally regardless of the outcome of a civil case. Civil cases will not result in a criminal record. A criminal sexual assault case is handled as a crime against the state and brought to the court by the state rather than by the accuser. Therefore, the accuser doesn't have to say in the direction of the case, but only appears as a witness for the prosecution. The primary purpose of a criminal sexual assault case is to determine the guilt or innocence of the defendants of a particular crime, and the prosecution must prove beyond a reasonable doubt that the defendant is guilty. The defendant is presumed innocent until proven guilty. A sexual assault defendant in criminal court can be ordered to pay the accuser, but only to compensate for financial costs incurred by the accuser. If a defendant is found guilty, outcomes can include incarceration or probation. If a person is found guilty of a sex-related crime in criminal court, it is virtually impossible to prove during a civil case based on the same incident that no damages occurred. If a defendant is found innocent of the crime, he or she can't be tried again for the same crime in criminal court. So let's talk about some courtroom logistics. Before you arrive to court proceeding, there are some logistics you may want to consider. Check to see if there is a safe, quiet place to wait within the courthouse. In some states, they have designated victims, witness waiting areas. You are considered a witness in the trial, and it's possible that you will not be allowed in the courtroom until a specific time. This could lead to long waiting periods. Pack water, a snack, and something to keep you occupied, like a book or music. Discuss any safety concerns you may have with the legal professionals representing you. They may be able to arrange protective measures like a police escort or a no contact order. Some higher profile cases may catch the attention of the media and social media users. It's possible that there may be harmful or negative comments made by people who are not informed about the case. It can be difficult to ignore these comments, but it's important to focus on controlling what you can. Remember to practice good self-care during this time. Learn more about how some people use technology to hurt others, and consider these tips for survivors on consuming media. Be wary of posting on social media during the trial, as anything you post could be used against you. Talk to a victim's advocate or the prosecuting attorney about what you can and cannot say on social media to be sure it doesn't impact the case in any way. The next area deals with tips for taking the stand. It can be nerve-wracking to speak in public as well as in the courtroom. It's important to discuss concerns you might have with legal professionals who are representing you and supporting your interests. The following tips can help you stay focused and calm throughout your testimony. Allow yourself to take brief pauses. If at any time you're feeling overwhelmed, ask the judge or the prosecutor for a short break. Stay hydrated. Bring a water bottle and take sips of water throughout. If you feel yourself getting angry or frustrated, take a moment to pause. Keep your eyes focused on the person asking you questions rather than looking at the perpetrator or their supporters. Always tell the truth. If you don't remember something exactly, it's important to say so. If you say something you didn't mean or you think something came across in a way you didn't intend, you can clarify your statement. Ask the judge, "May I go back on something I previously said?" Answer the questions and nothing more. Don't volunteer additional information unless you are asked. If you don't understand a question, say so. You can always ask the attorneys to repeat or rephrase a question so you can better understand it. Every trial is different. If you have specific questions about testifying, check in with a victim advocate or a prosecuting attorney. After the trial. The end of a trial may bring a sense of release, or it may not offer the closure you were expecting. Keep in mind that your testimony and participation is often critical to building a case against a perpetrator, but it is only one aspect of all the information that is considered by a judge or jury. After hearing from the witnesses and the attorneys, the judge will set a day and time to announce the sentence in what is called the sentencing hearing. These hearings can be held the same day the trial ends, or it can be days, weeks, even months later. You don't have to attend if you don't want to. If a judge and or jury find the defendant not guilty or issue a punishment you feel is not reflective of the crime, it may be difficult to hear. If the alleged perpetrator is acquitted, it does not mean that person is innocent or that the jury doesn't believe your story. Rather, it means there isn't enough evidence to make either decisions beyond a reasonable doubt. My story with the courts. I mentioned earlier that you have the rights to attend criminal justice proceedings and to speak during those proceedings. I was told in my first court case that I could not testify, that I would not be strong enough witness because I had previously dated the guy that I was not charging with rape. In the words of the prosecutor, they will eat you alive. This man not only raped me, but also three other women. Long story short, I was stripped from this right and did not learn until recently that no one can stop you from testifying in court against your assailant. Here are some words to the wise. Go to court before you have to go to court. At the time of my court hearing, I could not afford an attorney, so one was appointed to me. I had never been involved in any courts and had no idea what to expect. Most all states would allow you to sit in on court proceedings pre-COVID. Once COVID is over, it would be a good idea to just go to the court, sit in on the procedure, and see how it operates. This will give you an opportunity to not fear the courts if you ever have to go, and also allow you to ask questions to friends and families, or when the time comes, an attorney that will represent you. I close with two of my favorite quotes, and that is by Sir Francis Bacon, who stated that knowledge is power. And most importantly, that of the Holy Bible says, Proverbs 2:10-11, for wisdom will come into your heart, and knowledge will be pleasant to your soul. Discretion will watch over you, understanding will guard you. It's important to know your rights, and it's important ensuring your voice is always heard. Be blessed.